in light of the change of user, and 5, state the fate of the residents of Mkamenyi village who are to be allocated part of the land for a settlement. I thank you, Mr. Speaker.
Senator for Meru, Senator Gathuri Murungi.
Mr. Speaker, sir, I rise pursuant to Standing Order 53.1 to seek a statement from the Standing Committee on Justice, Legal Affairs and Human Rights regarding the governance issues in Meru County. Mr. Speaker, sir, there have been governance issues in Meru County since the general elections of 2022, marred by an ending conflict between the governor of the county and the County Assembly of Meru. Most recently, Mr. Speaker, the County Assembly attempted to impeach the governor, who sought reprieve in the High Court at the Meru Law Court. The court directed the parties to attempt to resolve the matter through alternative dispute resolution (ADR) mechanisms facilitated by the Njurincheke Supreme Council of Meru Elders. Mr. Speaker, sir, I am aware that the matter is still active in court, and without offending the provisions of Standing Order 101 in relation to the Honorable Judge and the orders of the court, I request the committee to, number 1, explain the linkage between bodies outside the judicial structures and the court system, explaining the role of such bodies in facilitating the solution of matters found in the courts. And 2, outline any measures put in place to ensure continuous capacity building for judicial officers on evolving cultural dynamics within the stations of the judiciary. And 3, explain any measures put in place to ensure that ADR mechanisms are sensitive to cultural dynamics and not offend the right of parties for fair hearing. And Mr. Speaker, as I issue this statement, I want to confirm to Mboni Karwale and the members that I'm a senior member of Njurincheke Council of Elders. And as
Senator for Meru, don't debate your statement.
Elder, it is
have your seat. Don't debate your statement, please. just take your seat. Statements pursuant to Standing Order 58, the Honorable Mohammed Chute.
Thank you very much, Honorable Speaker. Today I have a statement on false reports of my arrest by the Ethics and Anti-Corruption Commission. Mr. Speaker, sir, I rise pursuant to Standing Order 58 to make a statement regarding the false reports of my arrest by the Ethics and Anti-Corruption Commission, EACC. I would like to categorically state that I was not arrested by EACC on Thursday, 11th June 2024, as falsely stated by the Chief Executive Officer and the spokesperson of the Commission. Mr. Speaker, sir, in respect of my appearance before EACC on the specified date, I wish to clarify that I was at EACC offices upon invitation. I believed that the invitation arose from the several complaints I had made to the Commission regarding misappropriation of funds in Marsabit County. Mr. Speaker, sir, upon appearance at the EACC alongside my lawyer, I was informed by investigating officer that the information required of me then related to the ongoing investigation into alleged acts of corruption by the governor of Marsabit County and not myself. Honorable Speaker, I was asked about approximately 7 million shillings transferred by myself and my spouse to the governor in August 2017, which was before His Excellency Mohammed Ali and myself were elected governor and senator respectively. I explained that the transfer related to a fundraising event that were held at Lake Regency. I was also asked about 2 funds transfers, as well as 2 vouchers of 1.4 million shillings and 6.4 million shillings paid to my company by the county government of Marsabit. Mr. Speaker, sir, it is quite concerning that immediately after the CEO and the spokesman, thereafter, the CEO and the spokesperson of the Commission made a false press statement that I had been arrested and was under investigation for conflict of interest and theft of public funds to the tune of 365 million, as well as embezzlement of public funds to the tune of 2 billion shillings. At no point was I questioned on any of these matters, Honorable Speaker. I therefore challenge the CEO and the spokesperson to make public any evidence contradicting my account. In any case, Honorable Speaker, the statement recorded by myself on the said date could be sufficient evidence. Mr. Speaker, sir, it is my considered view that the CEO's action are retaliatory and driven by personal vendetta stemming from my remarks during the sitting of the Senate on 26 June 2024, calling for disbursement of EACC failing to fulfill its mandate. And I will say it again and again and again. I have therefore instructed my lawyer to institute legal suit against the CEO and the spokesperson for defamation and character assassination. In the coming days, I will also be seeking an update on the progress of investigation by EACC into the issues raised in the complaint I submitted to the Commission. These complaints date back several years, including period before I was elected senator. I thank you, Honorable Speaker.
Now, honorable senators will allow 30 minutes of intervention. It is now 3:32, so we will terminate at 4:02. Senator Manzo.
Thank you, Mr. Speaker. Mr. Speaker, I would like to deal with the matter of the Honorable Lemonen, Senator for Turkana. Mr. Speaker, from Nairobi to Kapendo, where he was talking about a road which should be going into Turkana, is 300 kilometers, and then within Turkana is about 400 kilometers, Mr. Speaker. Mr. Speaker, from a recent report on television, Citizen TV, it showed that particular area and Kenyans from that county, Mr. Speaker, complaining of how transport it is very difficult, that no private persons invest there in transport, that unless the police assist the residents of Turkana, that the traveling is very difficult, Mr. Speaker, and therefore doing of business in that particular county is very difficult, owing to our very old colonial bridge. Mr. Speaker, I'll want to support his statement so that Kenyans can be served equally, and that a serious effort be made there by the Minister of Transport to make sure that although not everywhere there are good roads, and also together with the devolution, that the people of Turkana are better roads and better for security. Secondly, on the Meru matter, Mr. Speaker, this is really new jurisprudence. As much as ADR is advocated by the courts, and even that there is an ADR Act, Mr. Speaker, this is a matter which was within the jurisdiction of court, and in the alternative also within the jurisdiction of this House, Mr. Speaker. Therefore, it is such a matter constitutionally which should be dealt by this House or the House in Meru, and in the event there is a suit filed, there is a likelihood, just like the Honorable Senator has said, that is a member of Judicial and is also a member of this House, and therefore likely to participate when the matter comes to the House. Mr. Speaker,
What is your point of order, Majority Leader?
Sorry, Mr. Speaker, apologies to my colleague for interrupting him, but it's just a concern. There is a guidance perhaps you should have given, Mr. Speaker, on how much time you give to each individual senator, because the allocated time is only 30 minutes. To best of my recollection, I think Senator Mahanzo has already done 5, so leaving 25 for the rest of all of us. Mr. Speaker, perhaps you could guide so that each senator who rises to comment can be limited to a specific time period. My kind indulgence.
No, honorable senators, the time allowable for intervention on statements is not more than 30 minutes. And that's why I've given the maximum to the entire Senate. So as you speak, be mindful of that fact. I know that a senator rising to speak has 20 minutes to speak. But again, you have to view that against the standing order that gives 30 minutes for intervention on statements. So if we can keep it 2 minutes each, then we'll be able to hear as many as will be willing to speak. Senator
of the company is Shanta Gold, which is exploring gold in the boundary between Vihiga and Siaya. But in the true sense, they are actually mining gold, and they are taking advantage of the people. There is no public participation, there is no proper engagement, there is no CSR. Mr. Speaker, I think this is a very serious matter, and I thank Senator Onyonka for bringing up this matter, and the committee concerned should dig deeper into this matter so that such companies which exploit our people are brought to book and action is taken against them. Mr. Speaker, I support.
Senator Chiranke.
Mr. Speaker, thank you very much. I want to comment on the statement by Deputy Speaker, Senator Katuri Murungi, on the issue of decision by Meru Court. Mr. Speaker, I was shocked as a legal practitioner that with the reading of Article 159, when you want to do ADR, the exception has been provided by Article 159(3). That traditional dispute resolution mechanism shall not be used in a way that contravenes bills of rights, repugnant to justice and morality, and results outcomes that are repugnant to justice or morality. C, it is inconsistent with this constitutional and written law. So, Speaker, under Article 181, the removal of a governor is a constitutional matter. I'm happy that Njuri has recused himself from that matter and has written to the High Court to move themselves from that matter. I find it mischievous, with all due respect for that High Court judge, to refer matters that should not be entertained under ADR, because this is a constitutional matter. So, Speaker, if it was issues of marriage, succession, and other matters that are of personal nature in the definition of law, then the High Court could refer. Mr. Speaker, the judiciary must be called out. I saw in a matter of Garissa County, where the governor has appointed more than 30 chief officers. The members of public went to seek an injunction, but the judge at the Garissa High Court ignored and allowed the process of vetting and appointing of 30 chief officers, Mr. Speaker. We have seen the matter of KFKF Football Federation, Mr. Speaker. So is now judiciary or judges a stumbling block against Kenyans seeking justice? I tend to agree so. I want to thank the High Court judge in Eldoret when Governor Sang reappointed CCM without seeking recourse, Mr. Speaker, to the County Assembly Approval Act. The High Court ordered him to do vetting again, Mr. Speaker. And therefore, those cases must be...
Senator Richard Onyonka.
Mr. Speaker, I'm just going to make a very short comment about the matter that Honorable Chute raised. And I want to bring the attention of this...
Senator Onyonka.
Yes.
That statement is not available for debate under Standing Order 58. It's a personal statement.
Oh, my apologies, sir. Mr. Speaker, I got a bit confused. I wanted to say that I have seen that Nchurincheka has actually made a withdrawal of the matter from the High Court. And I just want to mention to this House that if there is anything that we need to do is make sure that we protect and ring-fence our responsibilities as the Senate and other statutory bodies to make sure that our country is governed well and we maintain law and order. Thank you, Mr. Speaker.
Senator Gloria Oroba.
Thank you, Mr. Speaker. I would like to make a comment on the Deputy Speaker's statement with regards to the county government of Meru and the issues that they're having there, Mr. Speaker. My sentiments to this is that it appears that other parties, including the judiciary, feels that the Senate perhaps does not know the work that we have been mandated to do, Mr. Speaker. And in that essence, I would like to call upon the Committee of Devolution, because we do have a committee here that is in charge of devolution. And I'm wondering what they have been doing throughout this time, even when we were aware that the county government of Meru was actually having issues and going to court, Mr. Speaker. Mr. Speaker, I also want to maybe bring to light that in the event that as a Senate we feel, because I know that as senators, most of us here, we've had conversations, we feel that the county government of Meru is not working and it is not able to actually deliver. In the event that this is a common feeling, Mr. Speaker, we can also bring a petition here in terms of dissolving that county, Mr. Speaker. But having outside parties telling us that they are going to sit on alternative dispute resolution when we are still here, when we are in session, Mr. Speaker, I think it's an insult to this institution and to this House. So therefore, I call upon the Committee of Devolution to either persuade us, maybe through a motion or a petition or something, so that we can be able to handle this matter as a House that is there to support and fiercely defend devolution. Thank you, Mr. Speaker.
Senator Wambua Enoch.
The Speaker, thank you for this opportunity. And I want to just thank the Senator for Meru for bringing this matter up as a statement and for the opportunity for members to ventilate on this matter. Mr. Speaker, two things. One, what the judge did in referring this matter of impeachment to the Nchurincheka was a clear affront against constitutional hygiene. The matter of impeachment is a constitutional issue. In fact, the courts have a role to play at the end of the process if a party in the impeachment is aggrieved. For the judge to go on record and say that this is one of the most complicated and serious cases that he has ever encountered, then the Speaker, without discussing the character of the judge, I wonder then if this matter is so complicated to a High Court judge, what will happen when he is confronted with serious matters? The Speaker, that was an admission on the part of the judge of serious deficit of capacity to deal with a very simple matter. Mr. Speaker, the second issue is that I would want to challenge the Senator of Meru. I know this may be a bit complicated for him, but to consider going forward to cause to be invoked Article 187 of the Constitution, especially for critical functions and roles in the county government of Meru. Seriously speaking, the Speaker, the county government of Meru is dysfunctional. There will be need to consider transfer of services to another entity of government, especially for critical services, so the people of Meru can be served. And Mr. Speaker, I want to declare this on this floor, that when that matter comes here, and I know I should not be doing this, honestly, we must just deal with this Meru issue once and for all. Let's finish with it. And if it means the entire assembly going home and the governor going home, so that the people of Meru can also get the benefits of devolution. For now, it is a circus between the assembly and the governor, and the people are suffering. Consider invoking Article 187 of the Constitution on critical services, roles and functions in the county government of Meru. I thank you, Mr. Speaker.
Senator John Methu.
Thank you very much, Honourable Speaker. I also would wish to comment on the statement that has been sought by the Senator for Meru. And Honourable Speaker, just as my colleagues have actually said, this is actually a new, and we were just conversing here with the majority leader. Since this is a constitutional matter that had been brought to the attention of the judge of the level of the High Court, Honourable Speaker, and you say that this matter must be addressed. It's a very serious matter, so you send it back to Judicial. Two things, Honourable Speaker. One, the Senator for Meru has confirmed to us that he is a member of the Judicial. So how is he supposed to address this matter? If the County Assembly of Meru processes this motion, it will come to this particular house, and he will sit here as a senator, and he has sat on that matter during ADR. The second question we are asking ourselves, if this jurisprudence was what will be carried, what if tomorrow the judges of the Supreme Court, considering a presidential petition, ask the players and the parties to go and for ADR, they ask the National Conference of Catholic Bishops or the Islamic Council or the Council of Imams to go and arbitrate over this matter, Honourable Speaker. And finally, looking at the reading of Article 159 on where traditional dispute resolution mechanisms can be used, it does not come in on a process that is very clear in processing an impeachment motion. It is processed at the County Assembly. After the County Assembly, it comes to the Senate, Honourable Speaker. It has no other route. So for the judge to now say that you are taking this matter to the Judicial, and I'm very happy that the Judicial of Meru have actually said that they don't have the capacity to look at this matter. And it then brings the question, what if this matter was a matter that had been taken to court in another county that does not have a council of elders? What would have been the ruling of this particular case? So we are very disappointed, and I agree with the leader of majority, Honourable Speaker, that even as we give powers to the judiciary, they must be then also accountable. To whom are they accountable, Honourable Speaker? We as this House are accountable to the people of Kenya after every 5 years. We are subjected to an election after every 5 years. Who are judges accountable to? Even when you have made such an affront to the Constitution, even basic common sense, Honourable Speaker, who is that judge accountable to? So I would wish to say, just as the Senator for Kitui has said, on this particular matter of Meru, this time, we as a Senate, we have to ensure that the people of Meru actually get justice. They are not children of Aresa God, Honourable Speaker. We have to do everything that we can, including everything.
Senator Methu, that matter is not before us, so we cannot do anything. Just wait till maybe it gets here. Senator Hezana.
Thank you, Mr. Speaker. And I rise to contribute on the statement by Honorable Chute, the Senator for Marsabit, on the operations of the Northern Rangeland Trust in Marsabit County and obviously in the whole of northern Kenya as far as its name is concerned. Mr. Speaker, this statement comes at a time when the President was very clear about foreign organizations meddling in the peace, stability, and sovereignty of our nation. And in the same breath, Mr. Speaker, I would also want to know if NRT can disclose if they have any armory within their headquarters, and if there have been any deaths in the northern parts of Kenya that have been associated with them, particularly for the Samburu community, and what they have to say on that. Mr. Speaker, the carbon credit has been the new gold in northern Kenya. It has been a booming business where NRT is reaping millions of dollars. It is important that they disclose their financial records and make it public so that our people who majority are illiterate can be able to follow through on their financial compensation they are getting from whoever they are selling this carbon credit to. And it is also important that our people are given given enough information on how their land is utilized. And also, we do not see a reflection on the charities and the feedback or giving back they are giving to the community in the livelihoods of the people in the northern parts of Kenya. Thank you, Mr. Speaker.
Senator Bone Alvale.
Thank you, Mr. Speaker. Mr. Speaker, the issue raised by the Deputy Speaker is very serious. Mr. Speaker, there was no motion whatsoever before this judge to give him an opportunity to make this wild order. No motion. He did it on his own volition. And in so doing, he also made a pronouncement inconsistent with the Constitution. And Mr. Speaker, for this reason, I want to appeal to you that in accordance to Article 168 of the Constitution, Mr. Speaker, this judge has invited himself to removal from office. I therefore, Mr. Speaker, so as to send a clear message, please let this Senate move the Judicial Service Commission so that the Judicial Service Commission can then initiate the process of removing this judge. There are so many people who want to be judges. In fact, some of them very young.
What is your point of order, Senator Fak?
Is the distinguished medical practitioner and the majority whip in the Senate in order to attempt to discuss the conduct of a judge of the High Court without a substantive motion before this House.
Thank you, Mr. Speaker.
Boni, you need to adhere to the standing orders. You may not discuss the conduct of an officer who may not get a chance to rebut what you're alleging. So proceed.
Thank you, Mr. Speaker. Mr. Speaker, my second and last comment is on the matter raised by the Senator of Kisii. As mentioned by the Senator of Vihiga, Shanta Gold Limited Company is a big joke, and the Ministry of Mining must up the game. Shanta Gold has been in Kakamega, specifically Ikolomani, Bushiangala village, Isulu. It has been there, Mr. Speaker, for 15 years in the name of exploitation. And they have mined, Mr. Speaker, a total of 168 kilometers of a 2-centimeter diameter chain that goes through the tube they use for extracting.
What is the point of order, Senator Gloria?
Mr. Speaker, I just wanted you to clarify, because you made a ruling based on standing order 111 on contents of speech. And Mr. Speaker, when you read that standing order, it says, neither the personal conduct of the President, nor the conduct of the Speaker, or of any judge, nor the judicial conduct of any other person performing judicial functions, Mr. Speaker. And it says there, because the removal of the office if it's dependent on the Senate. Mr. Speaker, I just wanted to clarify, because also the statement, I wanted you to clarify, the statement that has been brought to the floor of the House by the Deputy Speaker, even the contents of the statement is alluding or seeking that a committee of this House actually discuss the ruling that has been made by the conduct of an individual that is on this 111. So are we also saying that that statement is out of order?
Senator Gloria, get hold of that statement by the Senator for Kathuri. It's very far from what you're alleging. Proceed and conclude.
Mr. Speaker, Shanta Gold has been in Ikolomani for those 15 years. And Mr. Speaker, they are pretending and they are being allowed to be still to be seen to be carrying out exploration when they are actually gutting away billions of shillings meant for the people of Kakamega. Mr. Speaker, this must be stopped. I was running on time so as to come back to the Senator of Mombasa. Senior Counsel, Senator of Mombasa, you must differentiate between me.
Address the chair, Senator.
Thank you, Mr. Speaker. The Senator of Mombasa is disappointing me. He's a senior counsel. He must be able to distinguish between...
Senator Boni, I've already ruled on the point of order raised by Senator Faki. Please do not go there. If you're done with your intervention, I may proceed to call Senator Eddie Okech.
They have not taken the mic.
Chair,
Proceed, Senator Eddie.
Thank you, Chair.
He'll be informed at the lounge.
Yeah.
Proceed.
Boni will be informed at the lounge. Chair, I want to make a quick comment. Chair, may you protect me from Senator Morgan? Mr. Speaker, Senator Morgan is heckling.
Senator Eddie. Senator Mogeni, what is your intervention? You still not to be settled. What is your intervention?
Yes.
Have a seat, Senator Eddie.
My neighbor, Senator of Migori, should know there is some language which is unparliamentary, including using the word heckling. Now, Mr. Speaker, I wanted to inform Senator Halwale that he should not mislead the country by making reference to the Senator of Mombasa 001 as being one of the lawyers who have been inducted into the role of senior counsel. For the record, Senator Halwale, Senator of Mombasa 001, has not been inducted to the role of senior counsel. So you are out of order by referring him to senior counsel Mohamed Faki.
Senator Eddie, proceed to conclude.
Chair, I hadn't even started yet, so I'm just starting.
Proceed.
Chair, I wanted to make a quick comment on a very important issue that Senator Onyonka has raised in this House through this statement on a possibility of auditing all our minerals and being able to account for all those minerals plus those companies that are involved in them, Mr. Speaker. Mr. Speaker, I think this is a very, very serious statement that as a country we must start thinking very critically about the minerals that we have and how we explore them. Because in the current world order, Mr. Speaker, you cannot think about any better opportunity that you can have as a country than any rare minerals that you have in the country to the extent that you can invest in them, Mr. Speaker. I want just to give an example, Mr. Speaker, that the current world order, you cannot think about areas of investment without thinking about what raw materials go into renewable energy. And because of the competition in the world in the area of technology, any smart technology for any smart electronic devices, Mr. Speaker, you cannot have them without thinking about raw materials that are coming out of this country. And Mr. Speaker, there is something called rare earth elements, which if you look at the demand of rare earth elements in the world, Mr. Speaker, at the pace of growth, by 2027, rare earth elements will have a 14% demand. Now, rare earth oxide alone, if you look at China, China has got about 85% control over rare earth oxide. And in this country, Mr. Speaker, our potential for rare earth elements is up to, in fact, over $100 billion. And Mr. Speaker, when you look at our current foreign policy, there is no articulation of even exploration of rare earth minerals in Kenya when we are engaging with the world's superpower in terms of technological advancement like the United States. You would have expected that if we are going to the United States, we have got accounts of these rare earth elements and the minerals that are ensuing from them, like in a county in Kwale, Mr. Speaker,
where we have got amazing rare earth elements that have been estimated by experts that could be able to fetch this country even $35 billion, Mr. Speaker. And our debt that we are struggling within the country today, Mr. Speaker, is barely 100 billion. If you have got rare earth elements in this country that can be able to, if we invest in them, they can be able to give us even up to 100 billion, Mr. Speaker. It will be very, very important that in this new broad-based government that we have, we start thinking critically about data-driven mining, data-driven decision-making in the mining sector, so that we see whether we can be able to explore our minerals to be able to deal with the issue of critical debt stock that we have in this country. Therefore, I want to support this statement and particularly draw the attention of this committee to look at the potential of Kenyan economy with regards to rare earth minerals that we can be able to explore and go ahead and even indicate how much money we need to inject in that sector and the potential revenues in terms of investments vis-a-vis returns of those investments that we can be able to make. Because as somebody who has looked at in this issue, Mr. Speaker, I am sure if you pumped 1.5 billion into the rare earth minerals in this country, you can make up to 30 billion at any given time. That means that every annual turnover on these issues, we can be able to actually even make money that can be able to guarantee us returns that can deal with debt. So I support this statement, and I hope that the relevant committee will look at it.
Senator Mwangaza.
Bwana Spika, ningependa kuchukua nafasi hii kukushukuru kwa kunipa nafasi pia na mimi nichangie maoni yangu kuhusu hoja ambayo imeletwa hapa na seneta wa Meru. Bwana Spika, Judicial Service Commission ni kati ya zile jopo ambazo zinaweza kuangalia makosa yoyote ambao mahakimu na majaji wanafanya katika kutoa zile hukumu zao. Kwa hivyo ningependelea pia kamati hiyo ya JLAC waangalie kama wanaweza kupeleka malalamishi kirasmi kwa Judicial Service Commission kuhusu hukumu ya huyu judge ambaye amesema kwamba kazi ambayo Senate ingefaa ifanye ipelekwe kwa Njuri Chenki. Pia Bwana Spika, kuna hili jambo la kwamba jaji wa mahakama kuu ya Kenya anasahau ya kwamba yule aliyechaguliwa pale ambaye ni governor wa Meru amechaguliwa na watu wote wanaoishi pale Meru. Mimi najua kuna Wapokomo, kuna Waorma wanaoishi pale Meru, kuna Wagiriama, manake Meru ukiwa unashuka hivi wanatuletea miraa sehemu ya huku kwetu, na kuna watu ambao wanaenda kufanya biashara kule na wamechukua kadi zao za kura kule. Kwa hivyo ikiwa kwamba kuna makosa ama kuna issue yoyote ya kutatuliwa, kwa nini judge anafikiria watu wote wapiga kura wote wa Meru ati ni wa Meru, kwa hivyo wanaenda kwa Njuri Chenki? Kuna wapiga kura pale ambao ni wa makabila tofauti, hata Wakisii wako pale, si ndio? Hata Wakikuyu wako pale, ambao ingekuwa ni makosa sana kwa jaji mzima kusema hawa watu wote hawa waende kwa Njuri Chenki ambayo ni ya kabila moja. Kwa hivyo tunataka Judicial Service Commission iseme kitu, na tunaomba kamati hii yetu ya JLAC pia ifikirie namna ambayo tutafanya malalamishi kirasmi kwa Judicial Service Commission kuhusu hukumu hii ambayo inapotosha watu wa Kenya na inahujumu mamlaka ya bunge la Senate. Asante Bwana Speaker.
Senator Joe Newton.
Thank you, Mr. Speaker, and I also rise to support this statement by the Senator for Meru, who doubles up as the Deputy Speaker of this particular House, Mr. Speaker. Mr. Speaker, this ruling by this particular judge was very disappointing. Why? Because when the county assembly members of Meru decided that they wanted to impeach Governor Kawira once again, they knew very well that there was a Judicial in Meru. Kawira herself, the governor, also knew very well that there was a Judicial in Meru in place. And she chose to take the matter, or whoever took the matter to court knew very well that there was this particular counsel, Mr. Speaker. And so I think the judge was out of order because you cannot refer. Mr. Speaker, I can liken it to somebody who has gone to a chief, who knows there is a chief, but goes to a DO. Then the DO tells them, go back to the chief. Mr. Speaker, this particular judge abdicated his responsibility. Mr. Speaker, when Governor Kawira was brought here for the last time on impeachment charges, she actually used Judicial as her defense. And in that defense, Governor Kawira convinced this Senate that actually her impeachment had been engineered by MCAs through Judicial. So, Mr. Speaker, we cannot then, this judge could not then have, was actually again out of order to have referred the matter to Judicial, which Governor Kawira already had submitted before this honorable house that it was behind her impeachment last time. And so, Mr. Speaker, this is a judge, for lack of a better word, that is irresponsible, and a judge that abdicates his responsibility. And even without discussing his conduct here, a committee, the JSC should do something about this judge, and the jailer committee in this house, Mr. Speaker, should also pursue this matter, and if possible, see whether these...
Sorry, Senator Kongo Mugeni, what is your point of order?
Yeah, Mr. Speaker, I appreciate the magnanimity of the issue at hand. But, Mr. Speaker, we also have, we have to be guided by our standing order, especially standing order number 1, which prohibits us from discussing the conduct of the judge. What we should be doing is to critique the content 101. Okay. What we should be doing, Mr. Speaker, sir, is to discuss the content of the ruling, but not to bring into discussion the personal character of a judge. That is prohibited by standing order number 101, which obligates us to bring a substantive motion with 3 days notice. But it's permissible, Mr. Speaker, to discuss how it is inappropriate for that judge to issue a ruling that directs that matter to Judicial. That is within our realm. To critique the decision, but not the person who made the decision, Mr. Speaker.
Mr. Speaker, I think Senior Counsel Omogeni was either not listening to my submission or is directly malicious against me, Mr. Speaker, because I never discussed the conduct of the judge, Mr. Speaker. I discussed the ruling, and I said this judge abdicated his responsibility by referring a matter to a council of elders whom the governor knew existed but did not refer the matter to him. And Mr. Speaker, I also said, and I beseech my senior Senator Kongo Mugeni to be more keen next time. I also said that Governor Kawira used this actually in her defense. She submitted before this honorable house that during Cheke was against her and is the one that had schemed her impeachment, Mr. Speaker. And so I said it was wrong to refer the matter, and I want to believe that Governor Kawira took it to court, refer her to a body that she believes is very hostile to her. And that is
Honorable Senators, I can see the time that was allocated. is over now. But let's last, but not that, at least one more, two more. One from this end, Senator Mandago. No, I'm winding up these things so that we can move on to the other one.
Yeah, me also.
Thank you very much, Honorable Speaker. Honorable Speaker, first I rise in support of the decision of the judge, Honorable Speaker. And allow me to be the devil's advocate, Honorable Speaker, because the Alternative Dispute Resolution Act 2021, which I believe was passed by Parliament, Honorable Speaker, in Section 4, Honorable Speaker, the Act shall apply to civil disputes, including a dispute to which the national government, a county government, or a state organ is a party to. Honorable Speaker, it has been argued that Meru County is not a county for Merus only. But if you look at the definition of the people that are involved, Honorable Speaker, it says a community means a social unit or groups brought together by different types of affinities, such as culture, dialect, race, family, neighborhood, faith, business, age, and common interests. The common interest in this matter, Honorable Speaker, is the issue of governance of Meru, Honorable Speaker. And Honorable Speaker, if we look at Article 159, 2C, alternative forms of dispute resolution include reconciliation, mediation, arbitration, and a traditional dispute resolution mechanism shall be promoted subject to Clause 3. Honorable Speaker, if you follow all the way in that act, it says the parties may terminate the ADR mechanisms at any point of their choice. Honorable Speaker, therefore, the county government of Meru, the Honorable MCS, can at any point decide they are not interested in the alternative dispute resolution mechanism and they can go back to court. The reason we established ADRs was actually to try and reduce the workload, the unnecessary workload we have in our courts on matters that can be sorted out of court through a process that this Honorable House and Parliament legislated and passed the law, Honorable Speaker.
So
I don't want to be informed by. I don't want to be informed by Senator Wambua, a person who refused to become the Attorney General of this country. If you cannot be one, you cannot purport to even imagine. You can inform me, Honorable Speaker. Honorable Speaker, I therefore want to agree with the judge.
Senator Wambua. Yes, proceed.
I want to agree with the judge in Meru.
That's a minute, Senator Mandago.
Mr. Speaker, I am very surprised that a man of the character of a senator for Uasin Gishu, who is dealing with his own issues, whichever issue that he's dealing with, can stand on the floor of the Senate and connect me with a nomination for the office of the Attorney General. Mr. Speaker, I am not a lawyer. It is the same mistakes that they made when they made the first appointment of the AG by not consulting properly. Mr. Speaker, I want the senator for Uasin Gishu to withdraw any connection between the senator of Kitui and the office of the Attorney General before or then, unless then he wants us to follow that route, Mr. Speaker.
Under which is standing order, Senator Wambua? Because you are seasoned member. Yes. Senator Wambua knows exactly what he wants.
Mr. Speaker, standing order 105.
Yes.
A senator must be responsible for the facts that he alleges on the floor of the Senate.
Yes, Senator Mandago.
Honorable Speaker, I wish to withdraw and apologize, but clarify that as a principal advisor of party leader of Wiper, who is a lawyer, who was given the offer. Honorable Speaker, I withdraw and apologize. Thank you, Honorable Speaker.
Senator Kisang.
Thank you, Honorable Speaker. Honorable Speaker, I want to comment on two of the statements, one by Onyonga. Honorable Speaker, there are some entities, there are some companies that have been given licenses to explore minerals, but some have gone ahead and done mining, but they continue reporting that they are exploring. These are the companies that we need to call out so that they can apply for the next license to mine, so that our communities can get the right income, Honorable Speaker, from these particular companies when they export the minerals, Honorable Speaker. Honorable Speaker, my last comment is on your statement as the Deputy Speaker on Meru, Honorable Speaker. Honorable Speaker, for the last 2 years, you know your county, your people have not received adequate representation, especially in terms of delivery of services, Honorable Speaker, because of the county assembly and the governor have not had good working relationship, Honorable Speaker. That's why in under 2 years we've had like 2 or 3, 4 impeachments, Honorable Speaker. So when I heard the church in Meru referring the matter to ADR, I thought this was court sent for these particular 2 warring groups, Honorable Speaker, to sit down and agree to work for the people of Meru. If they cannot sit down and work for the people of Meru, Honorable Speaker, I agree with what my colleagues, Gloria, that maybe it is time that we come up with a petition to dissolve this particular county. Let all the MCAs and the governor and the deputy governor go home so that basically you can go back for fresh elections. In Meru, we get a new governor, new deputy, and new MCAs, Honorable Speaker, so that things can work for the people of Meru. You can also decide to resign Speaker and you can run for the position, Honorable Speaker. But I believe the fake fertilizer will not run for that particular issue, Honorable Speaker. Honorable Speaker, that is my take. During Cheke are respected. I don't know why they've run away from adjudicating, from reconciling these particular people. That's it.
Thank you, Senator Kisang. Senator Kongo Mogeni.
Thank you, Honorable Speaker.
Senator Mogeni, Okongo Mogeni.
Hello? Yeah, Mr. Speaker, you know, we should not hit the judge so hard. You know, this constitution created an article called Article 159 on alternative forms of dispute resolution. And I want to inform senators here that even people who have committed murder have been referred to mediation, reconciliation, arbitration. So you cannot attack the ruling that was delivered by the judge because he was invoking an article that is in the Constitution. And you know, senators, you should read. Article 159 speaks of judicial authority, the power that is donated to the judge to give ruling and directions. But Speaker, I want to thank the injury check because I think injury check have seen the light. I read that they have applied to withdraw from the proceedings. And they want to allow that matter to run the full course. You know? And under Article 181, it's us, senators, who gave powers to our MCAs to initiate an impeachment. So now that the injury check, and I want to thank them because that's why we're here to deal with issues of impeachment. Now that injury check have seen the light, they have allowed this motion to run its full course. Let it be processed by the members of Meru County Assemblies. Let it come to the Senate. Can you see the Senate of Nyandarua is salivating. Let it be processed, Mr. Speaker. It comes here and we deal with justice. You know, Mr. Speaker, we must respond to the issues that are being raised by the MCAs and the residents of Meru. So let the judge, now that injury check have applied to allow that matter run its course, let the judge allow it to be processed, come to the Senate, and we do what we are supposed to do. Mr. Speaker, nobody should fear the senators of the Republic of Kenya, including Governor Kawira. If I was her, I will not even bother to go to court. If she is clean, let the matter come here. We deal with it. If she is clean, she is acquitted. If on the other hand, she has committed issues that make it undesirable for her to continue holding that office, then again she should fall on the doors of justice. So there is nothing to fear. Both ways, there will be justice. If she is innocent, an acquittal. If she is guilty, she should go home. That's why we have accountability, Mr. Speaker, in our Constitution. Thank you, Mr. Speaker.
Senator Chute, you know I cannot see your request on my screen. I don't know if there is.
Thank you very much.
He has a constitutional matter that is raising.
Thank you very much.
I cannot see his request. And that's the last one. Then we proceed with the other business.
Thank you very much. I wanted to add my voice on the issue of Meru. Honorable Speaker, my friend Senator Mandago quoted an article which he read halfway. And this is 159. If you look at 159C, alternative forms of dispute resolution, including reconciliation, mediation, arbitration, traditional dispute, resolution mechanism shall be promoted subject to clause 3. And clause 3, Honorable Speaker, says, traditional dispute resolution mechanism shall not be used in a way that A, contravenes the Bill of Rights, B, is repugnant to justice and morality, or results in outcomes that are repugnant to justice or morality, or C, is inconsistent with this Constitution or any other written law. Honorable Speaker, Article 181 is very clear. It tells us how to remove a governor from the office and the deputy governor also. Honorable Speaker, I'll give you an example of Marsabit. We don't have Njuruncheke in Marsabit. What will happen if the members of the National Assembly want to impeach the governor? Are they going to ask for Meru Njuruncheke to come and help us there? No, it is not possible. Again, Honorable Speaker, if the issue being raised by itself has some criminality issue, wastage of funds, resources, misappropriation of money, yes, it goes against Article 6. So, Honorable Speaker, I really thank the Njuruncheke for referring back that issue to the courts. And we are waiting for Governor Kawira Mwangaza here before the Senate. We are ready and waiting for her to come here. Honorable Speaker, finally, I think it is very important for us to look at the law. This Constitution, 2010, is one of the best constitutions that any person can have, especially in African countries. Let us not ignore this Constitution and follow traditional ways to solve some official issues. Thank you very much, Honorable Speaker.
Thank you, Honorable Senators. Now we proceed with the business of the day, and standing under 45.2, I wish to reorganize the business of the House this afternoon. So we move to standing on, we go to order number 21. Then after we execute that, we go to the normal system. So, clerk, read the order number 21.
Order number 21, the Land Amendment Bill, National Assembly Bills number 40 of 2022. Second reading.
Majority Leader.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the Land Amendment Bill, National Assembly Bill number 40 of 2022, be now read a second time. Mr. Speaker, this is an extremely important matter, despite the fact that it's one of the shortest bills that I've ever introduced in this House, but it serves an interesting purpose, Mr. Speaker, where we are seeking, Mr. Speaker, to secure public land for public institutions and ensuring that after such is done, Mr. Speaker, we provide the legal mechanism for the titling of such land. As it is today, Mr. Speaker, many public institutions actually continue to lose land that has been set aside for them on account of vague provisions of the law on the titling process of such parcels of land. And therefore, Mr. Speaker, hence the Land Amendment Bill, National Assembly Bill number 40 of 2024, which was published in the Kenya Gazette Supplement number 165 of 2022 on the 28th day of October in the same year. This bill was considered and passed by the National Assembly, after which they referred it to us for consideration. And I've explained, Mr. Speaker, that the principal object of this bill is to amend Land Act number 6 of 2012 in order to provide where public land has been allocated to a public body or a public institution by the NLC for a public purpose, or where the land set aside by persons or even a land buying company for public purpose, the Registrar of Land under the Land Registration Act of 2012 will issue the certificate of title in the name of public body, public institution, or the relevant ministry, as the case may be. So, Mr. Speaker, the key word or operating principle in this bill is public. Public land, public institution, and for a public purpose, Mr. Speaker. Therefore, it is a sacred move, if I may call it so, Mr. Speaker, because we all know of public institutions that up to date continue to lose land on account of either poor titling or the lack actually of legislative intervention on our part, Mr. Speaker, to ensure that after a donation has been made, Mr. Speaker, or even an allocation or setting aside of a public piece of land, Mr. Speaker, to a public institution, it is titled in the name of that institution. Mr. Speaker, Kenyans' obsession with land is legendary. And therefore, Mr. Speaker, there is need actually to ensure that our public institutions have their land firmly secured by ensuring that the title is registered in their name every time that land has been set aside. You know for a fact, for example, Mr. Speaker, that in many of the urban spaces here in Nairobi, there were public pieces of land that were set aside either for playground or social amenities, Mr. Speaker, but today cannot be traced. In fact, 70 to 80%, my own honest estimation, I have no strong data to back that up, but just based on my common knowledge of this city, Mr. Speaker, that land today you cannot trace it to the public purpose for which it was meant or for which it was allocated to. For the simple reason, Mr. Speaker, that we didn't have this provision to ensure that we title those lands in the name of the public institution or entity, Mr. Speaker. And that provided ripe environment, Mr. Speaker, for marauding public land fraudsters, Mr. Speaker, to quickly change the provisions of or the title, Mr. Speaker, of that particular land and own it, or even do developments that are otherwise not public or not meant for public good. We have many examples, Mr. Speaker. In the last Parliament, Mr. Speaker, and I think I have seen even a petition before this House, we had petitions from, say, Nairobi Water Services Company, where staff houses belonging to that institution, Mr. Speaker, a contractor showed up on site with a group of young men, as is normally the case. They demolished the houses in the dead of the night, and quickly, within no time, Mr. Speaker, they put up high-rise apartments. And years later, up to now, Mr. Speaker, because, and it's part of what we were discussing a few minutes ago, that sometimes our judges also choose to be mechanical. All they ask of that public institution is, where is the title? despite the fact that there can be provisions of letters of allocation, minutes of the council meeting that provided the setting aside of that parcel of land, Mr. Speaker, for public use. Many times, Mr. Speaker, in the absence of a title deed, public institutions have lost land to fraudsters, Mr. Speaker. And that is what we are seeking to address in this particular bill. As it is presently, Mr. Speaker, public land and land set aside for public purposes by land buying companies continue to be grabbed by private persons, primarily because there exists no certificates of title issued in respect of that land. And I've explained that particular bit. Therefore, this bill, Mr. Speaker, seeks to provide for the registration of public land. You know the issues around even our primary schools, Mr. Speaker, especially in areas where land is of high value. Urban towns like Nairobi here and many other cities, Mr. Speaker, public institutions actually continue to lose land on account of the lack of legal provision to do that. Therefore, the issuance of legal certificates, Mr. Speaker, to these public institutions will be crucial towards curbing unauthorized land grabbing, illegal occupation. Occupation is a big issue, Mr. Speaker. You remember, I think late last year, or was it early this year, there was the issue around Mavoko and Athi River, where many of those public land, East African Portland Cement and NSSF, Mr. Speaker, they continue to fall victim to this kind of games, where certain portions of their land, they dedicate them and they know in future if they do developments, the people who live there will need public utilities like hospitals and schools, Mr. Speaker. The very parcel of land that they set aside for that purpose, Mr. Speaker, because it's not registered to any public institution, Mr. Speaker, that land has since been grabbed. And that dispute continues. I think even yesterday I saw something in the news on NSSF land. And you know, they have since become even more advanced to the point that they involve even the police, some of whom are supposed to provide, Mr. Speaker, security to that particular parcel of land. They are enticed, Mr. Speaker, and they are told that please help yourself out as well. And together they team up with fraudsters, and therefore public loses land. Furthermore, Mr. Speaker, when you establish a system where land certificates are issued to public institutions once the land is owned, we enhance the legitimacy in land transactions involving public land. Ultimately, the proposed bill will not only protect the integrity of public land, but also pave way for responsible utilization of these lands for the benefit of society as a whole. Reason being, Mr. Speaker, that land that has been registered, say, to a school, it will be impossible for somebody to cheekily register some quasi-public institution, as is normally the case. Normally people begin something that, like a church, or, Mr. Speaker, so many other institutions that from the look of it appear to be benefiting the public, but actually are used for private benefit, Mr. Speaker. Once you register this title in the name of a public institution, it becomes impossible, Mr. Speaker, for somebody to go ahead and use that particular land for any other purposes other than what it was meant to achieve, hence the importance of this bill. To the specifics, Madam Speaker, of this bill, Clause 1 is simply about the title of the bill, the Land Amendment Bill 2024. Clause 2, Mr. Speaker, provides for the amendment, the specific one. You are actually amending Section 2 of the Principal Act by inserting a new definition of registrar to have the meaning assigned to it under Section 2 of the Land Registration Act of 2021, a law that we passed here in 2021, Mr. Speaker. Clause 3 of the bill, Mr. Speaker, proposes to amend Section 12 of the Principal Act by inserting the following new subsection immediately after 280, subsection 12, which is now subsection 13, which reads that a public body or institution shall apply to the registrar for registration of public land allocated by the Commission in the prescribed form. Therefore, you provide the prescribed form for registering this public land, Mr. Speaker, in the name of that public institution, either present or even for future use. Many institutions, Nairobi University here, Kenyatta University, you remember the dispute about their land and the new KU hospital, Mr. Speaker, and allegations and counter-allegations, Mr. Speaker, of who the intended beneficiaries of that particular land will be. Section 14, or the new clause 14, Mr. Speaker, provides that the registrar shall register the public land allocated to a public body or institution by the Commission. It places a mandate, Mr. Speaker, on the Commission, on the registrar, Mr. Speaker, to actually do that registration. Lastly is on clause 15, which is pursuant to section 58 and paragraph 7 of the third schedule to the Physical Land and Land Use Planning Act of 2019, the registrar shall register the land set aside by a person or land buying company for public purpose consequent upon proposed development, Mr. Speaker. Just important to specify. 16, Madam Speaker, will be upon the registration of land under subsection 1415, the registrar will then issue the certificate title. In the case of an incorporated public entity, the certificate shall be in the name of that entity. If that entity, that public entity is already registered, Mr. Speaker. In the case of an incorporated public entity, the Cabinet Secretary of the National Treasury as a trustee. That's very important, Mr. Speaker, because in many developments, the setting aside of public land for future public use is normally futuristic, where citizens, out of their goodwill, actually dedicate a certain portion of the land and say, in future, we intend to develop this, either a university, a college, Mr. Speaker, a playground for young children. Mr. Speaker, it is important that this is registered. Mr. Speaker, I don't know if I am being overly creative. I have since seen a dispute where residents, Mr. Speaker, of public or private, Mr. Speaker, private developments have sued actually the developer, Mr. Speaker, on account of the fact that when they were purchasing the either apartment or the houses, Mr. Speaker, in the approved development plan, there was provision for public utility, like a playground, Mr. Speaker, or a hospital, or a nursery. Then, of course, as is often the case, Mr. Speaker, that developer changes their mind once the residents have moved in. And since the residents have no recourse in law, because ideally they don't own that piece of land, Mr. Speaker.
Sorry, Majority Leader, I'm lost. Are there two members who are moving the bill at the same time?
Why?
Because there is two voices. I'm hearing two voices. One from Senator Meru and another one from the Majority Leader. Who is moving the bill? Proceed is a Majority Leader.
You know, Nyandarua, Mr. Speaker, is famous for sending very intelligent old men. This is the first time they have sent a young man, Mr. Speaker. I didn't intend to say that, Mr. Speaker. But the young man will learn that you don't speak while the Majority Leader is moving a bill. Particularly, Mr. Speaker, a bill which he is supposed to second, and is coming in shortly. Mr. Speaker, the point I was making is that now, with the provisions of this new section 16, if you are a member of the public, you have bought into a private development, and that developer has set aside land, either to dupe you into buying into that development, or with the good intention of having that land set aside for actually your use, Mr. Speaker. This provision of the law can be cited to ensure that that private developer, Mr. Speaker, because this is not only to public institution, is actually registered, Mr. Speaker, for the intended good of that private development, Mr. Speaker. And since perhaps maybe there is no registered residents association, then you will have the CS for Treasury, Mr. Speaker, being a trustee, because that particular parcel of land will be set aside. I have since seen disputes, Mr. Speaker, where residents take up in arms and they say, wait a minute, when we were buying this development, we were assured that there will be a playground for our children. Why has the developer changed mind? But unfortunately, because of the absence of this law, Mr. Speaker, you find actually that those citizens have no proper recourse in law. This will now cease being the case after we pass this bill and it is enacted into law. In case of a county government, it will be in the name of the county government, Mr. Speaker, such that if that land is being set aside, say, for a facility, which the county government, say, a dispensary or something, it will be in the name of that county government. Mr. Speaker, sir, with these remarks, I beg to move and now request the very intelligent but sometimes distracted Senator for Nyandarua Senator John Methu to second.
Senator Meru.
Honorable Speaker, as I rise to second this particular motion, allow me to first make, with your permission, an observation that I have made on two of our very senior legislators in this House, the Senator for Tana River, Senator Danson Buya Mungatana, and the Senator for Kakamega, Senator Dr. Boni Halwale, who was a parliamentarian when I was a primary school kid. And Honorable Speaker, the observation that I've seen about the two legislators is that they take their legislative work very, very seriously. Rarely will you miss the face of Boni Halwale sitting from 2:30 to 6:30 every day, and it is the same case for the Senator for Tana River. I see the Senator for Kiambu a bit excited. He wants me to include him in that list. And anyway, because I am cut of the cloth of the truthful men, I'm holding back to including him in that particular list. So we are learning from the best. I understand the reason why I left primary school, went to high school, went to university, and still found you here. You have not left, you are still in this house because you are taking your work very, very seriously. Honorable Speaker, as I rise to second this particular motion that has been brought by the leader of majority, Honorable Speaker, I'm being distracted by the Senator from Kisii, Senator Grulia, who is actually pushing that it is now time for the Senator for Kakamega to now go and serve the people of Kakamega in other positions, Honorable Speaker, as a governor. But I think that is up to him. That he will make that choice. He attempted sometime, but many other things happened. Honorable Speaker, I am seconding this particular motion.
The motion.
Thank you very much. Thank you very much for your guidance. You're also a person that we are looking up to, having served in your since you're also serving in your third term, Honorable Speaker, because if then my calculations are right, you started serving in 2013 and I was still a student. So you're in that category of the people that would want that you keep serving this nation. Honorable Speaker, the purpose and the intent for this particular bill, as has been elucidated by the leader of majority, Honorable Speaker, is to ensure that all our public land is registered in the name of the institutions upon which this public land has been granted, Honorable Speaker. And the cure and the import of this particular bill, once it is processed and passed by this House, Honorable Speaker, is that as the Chairman, Committee on Lands, Environment and Natural Resources, 60 or 70% of all the petitions and the statements that are sought by members of this particular Senate and even members of the public, Honorable Speaker, they always have a question on either grabbed land, public utility, or an intent. This morning, Honorable Speaker, you know that we are dealing with the issue of the Siani wetland in Nyamira County, Honorable Speaker, where some people have made an intention of grabbing that particular swamp, Honorable Speaker. So, Honorable Speaker, if a public utility has been given ownership documents to land, Honorable Speaker, it will bring cure to the perpetual grabbing of public land. Honorable Speaker, you know, the way public utilities are wired, the leadership of public utilities keep changing. Today, the head teacher of this primary school will be the head teacher of another primary school. The board of management of this hospital will not be there tomorrow. The governor of this county will not be the governor after his or her 2 terms, or after 1 term, Honorable Speaker. So the leadership of facilities that hold public utilities, Honorable Speaker, keep changing, Honorable Speaker. And if then there are no proper documentation on the land that they own, it then breeds root to grabbing of this particular land, Honorable Speaker. It is the case for a primary school that we are dealing with a petition, Honorable Speaker, from Nyandarua, Magomano Primary School, which initially, if you look at the first mutation of the maps that we have, Honorable Speaker, the primary school has 28 acres. But somebody else has produced documents, ownership documents, and has left the primary school with 14 acres. And we are almost deciding to fate, Honorable Speaker, because the primary school does not have documents. The private person has the documents, Honorable Speaker. So it is upon this, that after the National Land Commission has granted you land, Honorable Speaker, then the second process and the second matter that should follow is processing that particular, the documentation of that particular utility. There's something else that has been the intent of this particular bill. You see, and I am sure the Senator for Kiambu will be very interested in this particular conversation. The dispute that you see in their Tattoo City development structure is that of the 15,000 acres parcel of land, there has been an intention to have 406 of that particular land be forfeited as part of public utilities for 3 primary schools, Honorable Speaker, and I think other utilities in that particular development. But now, as the development keeps growing, as the developer keeps growing, keeps developing, I think for the initial 5,000 acres, there was 406 acres that was supposed to go for private use, for public use, Honorable Speaker. But over time, as that value of that land gets growing, the developer keeps reducing that land. I hear that now, I know the Senator for Kiambu would have better details on this, Honorable Speaker, but I hear now it is below 100, Honorable Speaker, out of the 406. You can imagine a person who has developed 5,000 acres can only forfeit 1,000. If this law had been passed then, once they took this plan to the county government for approval, with the 406, a document or an ownership document would have been produced in regards to these 406 acres for public utilities, Honorable Speaker, and it would have been in the name of the trustee of the national, the CS for National Treasury, because that position will be there. The position of the CS for National Treasury will be there today, tomorrow, and every day. It was there in 2013 when that plan was taken. It is there still today, and it will be there every day, Honorable Speaker. So, had this document been produced in this regard, then we would not have the problem that we are having now. Finally, there is the issue that we are speaking about legitimacy. There's no point of a public utility keep saying that we have 26 acres, 27 acres, 39 acres, and you have no documents to it to show that it is your legitimate land. You legitimately own this particular piece of land, Honorable Speaker. And you know, government has, I think the biggest chunk of land in Kenya is owned by government. But without ownership document, where is the legitimacy that you own this particular land, Honorable Speaker? So with this, since this is a very straightforward matter, I wish to second.
Thank you. You second and then you sit down. Don't move on. So, Honorable Senators, I propose the question that the Land Amendment Bill, National Assembly Bills number 40 of 2022, be now read a second time. Can see several senators ready to contribute. We start with the Senator Chute Mohamed.
Thank you very much, Honorable Speaker. Honorable Speaker, I would want to contribute to this amendment bill. Honorable Speaker, if you look at number 13 and number 14, speaks about the same thing. Number 13 says a public body or institution shall apply to the registrar for registration of public land allocated by the commission in the prescribed form. And then 14 is vice versa. The registrar shall register public land allocated to a public body or institution by the commission. Honorable Speaker, I've seen on many occasions land buyers or owners subdividing plots into smaller units. But then before they get the approval, they must have a public utility facility, a parcel of land that has been allocated for that use. Honorable Speaker, many years ago, in South Sea and many other places, I will give you an example of South Sea, when they allocated those lands, when they subdivided, they left some land for public utility. After some years, Honorable Speaker, all the title deeds were offered, were given for the landowners, to the landowners, and the utility one was left without registration it was not registered to anybody. Honorable Speaker, after some years, someone will come and claim that land and register that land and sell it or develop some units of houses. Honorable Speaker, what this amendment bill, Bill number 2024, is trying to do is once you subdivide a particular land, that land should be registered. And what must be done first, Honorable Speaker, is to register that public utility land first. And the issue of registering it will make sure that that land will be preserved for the purpose that was intended for. Honorable Speaker, if you look at mosques, for example, a landowner can allocate land, subdivide land for his children or other relatives. And out of that, he will demarcate some part of that land for mosque use. And on many occasions, Honorable Speaker, after that mosque has gone, children will come and claim even that land. If that land is registered as mosque or as madrasa or as any utility, public utility space, I think the registration will deter anybody who will come and claim that land. Honorable Speaker, there is something that is very, very important in this bill. And this one is, look at 15, pass on to section 58, paragraph 7 of the third schedule to the Physical Land Use Planning Act 2019. The registrar shall register land set aside by persons or a land buying company for public purpose consequent upon proposed development. Honorable Speaker, and emphasis should be put in place that before anything happens, before subdivision is approved, that land should be kept aside, should be registered in the name of particular organization. If you look at how it was meant to be done, you go to number 16. Upon registration of land under subsection 14 and 15, the registrar shall issue a certificate of title. Very important, Honorable Speaker. In the case of an incorporated public entity, the certificate of title shall be issued in the name of the entity. These are mosques, churches, schools, and any other institution that has been given this land. And B says, in the case of an incorporated public entity, the Cabinet Secretary to the National Treasury shall, as trustee, register this company under that trustee. Honorable Speaker, this is very important. But what we need to do is this. Honorable Speaker, normally what happens in this country, it can be registered under National Treasury as a trustee. But then what we need to add, another amendment, if it can be done, is that land is not for sale, for resale. It is meant for a particular purpose. If it is meant for a hospital, it should remain for a hospital. If it is meant for school, for a school, that it must remain for the purpose that it was kept aside for. In the case of C, a county government should keep that land, register under the county government as a trustee. Similarly, Honorable Speaker, the issue of registering only is not that important. What is important, Honorable Speaker, is for even if, for example, the current governor or any governor leaves that office, another governor can come in and make excuses to register that land under other purposes and again reallocate it or subdivide it and sell it to other people. Honorable Speaker, A very good example I'll give you today. In Marsabit, there were land that were allocated to the government, and government houses were there, built in 1960s, early 1960s. Those land today, or the houses, were subdivided and allocated to individuals in that county. I have a statement in that regard, and I'm waiting for correspondence from the Committee on Land. Honorable Speaker, the issue of just saying it will be registered under a trustee is not enough. What needed to be done, and seriously looking at this amendment, if it is under a particular trustee, if it is the county government or the National Treasury, there must be curtailed that this land should not be used for any other purpose except for the purpose that was designed for. Honorable Speaker, even as we speak, there must be, in this particular amendment, there must be a way that all government land should be registered under the same, or if it is the county government, it must be registered to the county government so that it can be preserved, not for now only, for posterity. Honorable Speaker, after we leave this world, a new generation will come in. If this is not indicated, the purpose for why this land was preserved, then anybody can come and do whatever he wants. Finally, Honorable Speaker, the issue of public land and the issue of community land comes under the same issue. If you look at today, public land are being grabbed, and at the same time, similarly, community land are being grabbed. There is a delay in registering community land in Marsabit. Honorable Speaker, Lake Turkana Wind Power have taken thousands and thousands of acres of community land. This matter is before the court, and the court has given direction on how this dispute can be resolved. The Attorney General was given the mandate to reconcile the community and Lake Turkana Wind Power. But what is happening is Lake Turkana Wind Power are deliberately trying to delay the process. They are incorporating some of our members of parliament. They are neglecting others. They don't talk to others, and using those methods to delay the court process. Honorable Speaker, in support of this amendment, I would want to say, let us keep our land, both public land and community land, under strict, very, very strict regulatory position, so that we cannot just do what anybody can come and do whatever he wants if that land is not registered under a particular law, which this one does. Thank you very much, Honorable Speaker. I beg to support.
Thank you, Senator Mugatana Dansu.
Mr. Speaker, I want to thank you for giving me the opportunity to also make my contribution in this debate. On the onset, Mr. Speaker, I want to say I am very happy, Mr. Speaker, that I have lived long enough to start seeing the implementation of the Ndungu Land Commission report. Mr. Speaker, this is a very important bill. For those who lived in our times, Mr. Speaker, you will remember that the government released a report sometimes in 2004 that said that about 200,000 land titles have been issued irregularly, Mr. Speaker. And it was this concept of land grabbing that was blamed for this process. Mr. Speaker, what is land grabbing? Mr. Speaker, this is the alienation of public land for private entities like corporations or individuals, so that land that was made for public utilities, Mr. Speaker, is taken by individuals whom in those days we used to call people who are thirsty for quick making of money. Normally, Mr. Speaker, the process would be people would go to the Ministry of Lands and they would pay people so that they investigate which areas are open. And then they use processes within the Ministry of Land, quickly get that land allocated to themselves, and then they sell it for a profit. Today someone was walking, tomorrow he's driving, the next day he's buying a mansion because of this illegal land grabbing. Mr. Speaker, this land grabbing is one of the worst injustices that has occurred in this country, Mr. Speaker. And you know, in the 2010 Constitution of Kenya and the sessional paper number 3 on national land policy of 2009, the Kenya government actually recommended, together with this new constitution, that this is one issue that we need to deal with as fast as possible. Mr. Speaker, the phenomenon of land grabbing became a very serious issue during the 1990s. It became very pronounced, and Mr. Speaker, it became such a thorny issue that it greatly contributed to serious instabilities, Mr. Speaker, in the political circles and during election cycles, Mr. Speaker, because in 1992 there were land clashes, Mr. Speaker. In 1997 there were equally some land clashes, and every time people go to election and one side or the other loses, this issue would be played out to the public because it's an emotional issue that is a wound that has not been able to be healed. Mr. Speaker, even in 2002, the same thing was being hyped so that people become angry at the governments that have been chosen. Mr. Speaker, in the coast region, for example, a lot of people have felt that the government, successive governments, have not dealt with the land issues as they should, Mr. Speaker. You would find many people are bitter because land that was meant to be theirs, you are living there. You are not educated in the processes of alienation of that land to your community. You are not educated in the process of alienation of that land to you as an individual. Then somebody from Nairobi or elsewhere comes and tells you that this title is his. And Mr. Speaker, they don't come just like that. They come with police, they come with goons, whoever is available to assist them. And Mr. Speaker, in the coast, we have suffered a lot because of this kind of thing. Alienation of public land. People are living in communities, Mr. Speaker, that have not gone to get titles for those communities. And Mr. Speaker, you just hear a certain company has alienated 2,000 acres of your land. And Mr. Speaker, even to date, I am struggling in Tana River County with a problem in Hurara area, Mr. Speaker, where many people are living and they cannot get titles because a certain individual went, registered a company, hid under that company, and got over 3,000 acres of land near the beach, Mr. Speaker. And people have been living there, and they are not able to register just to discover somebody has that land in their name and written in the name of a company. So, Mr. Speaker, going back to history, in 2002, Mr. Speaker, because of the pressures and everything, the government, in response to what was happening at that time, decided, let